Good morning, good afternoon, everyone. Welcome to this joint CICA FIDIC webinar. We will wait a few minutes for we let the people join in, and then we will start this webinar. Welcome, everyone. Welcome. Welcome, everyone. So we will start in a few minutes. Okay, so we will start in 1 minute. Okay, Fanny, I think we can start.
Okay, thank you, Andine. Good morning, good afternoon. I am Fanny Dastug. I am the Director General of CICA, the Confederation of International Contractors Associations. Thank you very much for joining us today for this second episode of this joint series of webinars organized by FIDIC and CICA, which will focus today on the FIDIC Green Book Edition 2021. So as CICA, we have been very supportive of this short form, and we were part of the friendly review for its updates. So we hope it can be more used, in particular for the projects financed by the multilateral development banks. So today we will discuss the innovative features of the Green Book with highly recognized experts. Robert and Mahmoud will present the main and innovative features of the Green Book first, and then my colleague Richard will give the general feedback from the contractors and will also highlight a few points that may perhaps be improved. Finally, we will have Peter, who will provide the employer's views. We will, of course, introduce properly each speaker before their presentations, and we will keep time for questions and answers. You can type the questions and comments in the chat and or raise your hand during the Q&A sessions. But first, I will leave the mic to Daduna, with whom I am very pleased to co-moderate this webinar today. So Daduna, thank you very much.
Thank you very much, Fanny, for your introduction, and thank you, Andine. Good morning, good afternoon, and good evening to all participants joining us from around the world. Welcome to this second joint webinar. We are delighted to have you with us today. A special thank you to Fanny and CICA for collaboration and for making this event possible. We truly appreciate the opportunity to present FIDIC Green Book to such a broad and engaging, we hope, audience. My name is Daduna Gohreidze. I'm FIDIC's Chief Legal and Contracts Officer, and an absolute pleasure to co-moderate this session, Fanny, with you. We will begin today's session with a presentation of the Green Book by its drafter, as mentioned by Fanny. I will shortly introduce them to you and hand over to them to walk us through the key and innovative features of the Green Book, the second edition. But first, let me give you a brief overview of the short form of contract and about the objectives behind its publication and update by FIDIC. The first edition of the Green Book was published in 1999, and the second edition published in 2021 comes as an update of the original contract. It continues the FIDIC's core philosophy of risk-reward allocation as a balanced contract and is building on more than 2 decades of experience and feedback. The Green Book is a simple, user-friendly and concise contract, and it includes all essential commercial features and provisions that is required for a construction contract. While it is designed for projects where the employer provides the design, it is also suitable for cases where the design is partially or fully provided by the contractor. The contract includes multiple payment options to suit different project needs and has some innovative features, as will be explained in more detail by our panelists shortly after my brief overview. Though the Green Book is a short form of contract, the second edition is not intended solely for small, simple or short duration projects. The feedback from the use of the 99 editions has shown that the FIDIC Green Book has been used for projects with the value of more than $10 million and also for the duration longer than the time for completion of 2 years. And reflecting on that, the Green Book has been produced as an alternative to Red and Yellow Book of 2017 editions, for projects where the perceived level of risk is low, or where the parties prefer a simpler form or less contract administration. Accordingly, it can be used, and we anticipate it's used for more complex projects as well, and for high-value projects as well, considering that the above conditions are met. Since its launch, the Green Book 2021 has become very popular. It has been sold in 119 countries and has been translated into different languages, including French, Lithuanian, Bulgarian, and Bahasa, with the upcoming ongoing translations in Mongolian, Hungarian, Czech, and Vietnamese. And we thank all our member associations and partners for making this possible, and we will continue to produce translations in more languages in the coming future. We are delighted to be joined today by CERN, Peter will share the experiences of CERN on the use of the Green Book 2021 on their real project scenarios. CERN has also provided valuable support in translating the FIDIC Green Book into French language, and we thank CERN sincerely for their contribution to that. Furthermore, the Green Book has been included in the license agreements with multilateral development banks of some of them, and we hope to see more and more use of the Green Book in the bank-financed projects, as mentioned also by Fanny, and we already see the Green Book used on projects financed by, for example, by EBRD. In addition, for those who want to learn more about the FIDIC Green Book, FIDIC Academy has produced and is offering CPD accredited training on the use and application of the Green Book, and please get in touch with us and with FIDIC Academy if you are interested to participate in the trainings for that. With that, I would like to now introduce our first two panelists, the drafters of the FIDIC Green Book, who will present the new features and updates of the second edition. And let me first start by introducing Mahmoud. Mahmoud is a member of the FIDIC's Contracts Committee and acts as the CC liaison for Task Group 14, in charge of drafting a new standard form of contract for offshore wind farm projects. This is another initiative of FIDIC, which is in the pipeline. Mahmoud is a co-author of the 2021 Green Book and a friendly reviewer for other various FIDIC contract documents. Mahmoud has hands-on experience in drafting, adapting, and negotiating bespoke and standard form contracts. His experience includes working in Egypt, France, USA, and Middle East, and he has been working for Dolphin Energy Limited in Abu Dhabi since 2005, and previously held different senior positions with other employers. Mahmoud is a qualified engineer with over 30 years of experience in oil and gas, power generation and distribution, architectural and research projects. Mahmoud heavily participates in professional pro bono activities, including FIDIC, and is contributing to updating standard form contracts and regularly speaks on our conferences and events, and not only on FIDIC events, of course. As you can see, Mahmoud has a very broad experience and very relevant experience. Thank you, Mahmoud, for being here with us today. Let me also introduce Robert. Robert Wers is an independent dispute resolution practitioner serving as adjudicator, dispute board member, or expert in alternative dispute resolution procedures or in international arbitration. Robert has experience as adjudicator and dispute board member in complex, medium to extra large projects, and his appointments cover a broad range of industry sectors, including heavy construction, plant contracts, energy and natural resources, and so on and so forth. He's a panelist of the German Maritime Association of Arbitrators and UK Adjudicators and World Offshore Forum WIND. His skills as practitioner and in dispute avoidance are frequently sought on road, bridges, offshore, and tunneling dispute boards. Robert is also an expert, and he is publicly appointed and sworn for quantum and FIDIC conditions. He's also a fellow of the Chartered Institute of Arbitrators, the FCL certified adjudicator, listed on the FIDIC's president list of adjudicators, accredited as international FIDIC trainer. He is a principal drafter of the Green Book, and also currently he is in the task group working for establishing FIDIC's handbook for practitioners. That is another FIDIC's ongoing initiative related to FIDIC use of the FIDIC contracts, and Robert will also touch upon the communication tools that has been already included in the Green Book when he introduces the new features. With that, I would like to hand over floor to Mahmoud and Robert to lead us through the features of the Green Book and to present the book to all of you. Thank you for your attention, and Mahmoud and Robert, the floor is yours.
Thank you so much, Duna and Fanny, for the kind words and the extensive introduction. This is really humbling. Warm greetings to everyone from sunny and warm, if not to be more accurately, from hot Abu Dhabi to all of you. I would like to share my screen. I don't know if everyone can share already or not. Okay. See my screen now?
Yes. Perfect.
Okay, let's go. It's, of course, a great pleasure to be with you all today, especially for me and Robert, talking about a subject that is dear to our hearts, which is the second edition of the Green Book, which we both, along with the other two gentlemen that you see, whom you see the pictures now on screen. I will start from the left of the screen. Vincent Leloup, he was the principal drafter of the second edition of the Green Book. He is also our dear chair of the FIDIC Contracts Committee, and he does so many other things. James Perry, our friend, he's an adjudicator, an arbitrator, a consultant, an engineer, and a qualified lawyer. And of course, Robert Wirth, you heard about him from the Duna. He's a co-author of the Green Book and a dear friend. And of course, there is at the last, my humble self. And as Robert told me before we went on air, those pictures really show us when we were younger, and it seems, but I was the youngest. I was much greener at that time. So maybe for the next webinars, we need to change those pictures, although it reminds me of me when I was much greener. But anyways, so it was the four of us. I always like to call us the four green musketeers in alignment with the three musketeers. So these were the four co-drafters of the Green Book. So the objectives of drafting a new edition of the 99 first edition of the Green Book was to draft a form to serve as an alternative to the 2017 Red and Yellow books for projects where the perceived level of risk is low and or the parties wish to use a simple form that does not really require significant contract administration and management resources, like the case for the 2017 Rainbow Suite. We intentionally chose not to attach a price tag to the second edition of the Green Book. However, if by analogy, if we take a look at the MDBs, in particular the World Bank small works contract or form of contract, we submit and contend that the second edition of the Green Book is more than a perfect fit for those contracts valued by the World Bank up to $10 million. We really feel and are confident that the Green Book second edition can be a good fit for projects even higher than 10 million capital value if any of one or two or A or B conditions that I mentioned earlier apply. It can go, I mean, we don't want to also give a value, I mean, that can easily go to 30 or $40 million. The drafting objectives included maintaining FIDIC's balanced risk allocation, simplifying the contractual machinery, ensuring clarity and certainty, and updating and or expanding some of the main features included in the first edition. This slide was prepared by our dear colleague, Adriana Spasova. She's a member of the FIDIC Contracts Committee and a big advocate of the second edition of the Green Book. So kudos to Adriana. She prepared this to just summarize the objectives. It is intended to be a concise, flexible, user-friendly, innovative, and a simple form. And we hope that the market will see it and perceive it that way and use it in that sense also. In terms of structure, it starts by the standard parts, the acknowledgement, the foreword, extensive set of charts and illustrative sequence of events and some flow charts, and then the form of contract agreement. General conditions, 14 general conditions. The one in red font are either new or amended compared to the first edition. Then the appendix, including the rules for adjudication and the form of the adjudicator's agreement. Particular conditions in parts A and B, similar to the the older, bigger siblings of the Green Book, members of the Rainbow Suite, red, yellow, and silver. And then there are forms in the annexes, including one of the novelties in the second edition, which is an insurance certificate, which makes its way for the first time in the FIDIC form. Then we end with guidance notes, and including 40 communication forms that I think Robert will walk you through in more detail in a few minutes. Some of the new features, perhaps one of the main, if not the main new addition in the second edition of the Green Book is the incorporation of the engineer to administer the contract. But obviously the engineer will, similar to the 2017 red, yellow, and silver, will act neutrally between the parties when he or she proceeds under subclause 3.5 to agree or determine, and also is under the obligation to fairly certify payment. We, of course, were keen to align with the 2017 suite where applicable, We added more new definitions or amended existing. We added some boilerplate provisions. Of course, added, taken over certificates, date of completion, the DNP, and so forth. We tabulated all the employer's risks and the corresponding contractor's entitlement in one table under subclause 11.1.3, which is also one of the novelties. We expanded on the LDs provisions of the first edition, and now we have LDs for delay, including prolongation cost, which is, I think, one of the major novelties that also Robert will walk you through in a few minutes. There are LDs for termination, similar to the first edition with more expansion, and also for omissions. As Daduna mentioned earlier, the Green Book 2021 second edition is suitable for either employer and or contractor design. So it acts on either a smaller, younger red book or yellow book, two separate routes with distinct procedure for variations and claims, which were combined under clause 10 of the first edition of the Green Book. We added suspension and termination clauses, including termination for convenience, which was missed or not included in the first edition. Multiple valuation, similar to the first edition with more elaboration. Advance payment, which is now exclusive for the contract, and changes in cost in provisions added. Adjudicator appointed from the outset from a list in the contract data with 3 appointment options. Provides also informal assistance and with updated rules. Arbitration by default under the ICC rules of arbitration, the expedited procedure by one arbitrator in 6 months. So in fulfilling the drafting objectives, we have combined, as I mentioned earlier, the employer's risk and the corresponding entitlement of contractors, whether money and or extension of time, in a tabulated format under subclause 11. And obviously, if those risks, any other risk not mentioned in that list of employer's risk is, of course, assumed to be substantially and essentially a contractor's risk. So, as I said, the entitlements are subject to clause 13 claims, but they are listed for clarity and certainty. So, unless the employer would instruct a variation, in that case, clause 7 would apply. The entitlements vary based on whether the delay is compensable or excusable. I think for those of you who are familiar with the SCL delay protocol will be familiar with the two terms, compensable delay or excusable delay. We also explained that in the foreword and the guidance notes of the Green Book. So this is a screenshot of the table. It's an extensive table. Employers may not like it that much for the employer's risk and the corresponding entitlement, as you can see. And that's the balance of that table. And as I said, if it is a compensable delay, then the contractor would potentially, subject to clause 13 claims, would be entitled to EOT plus cost or EOT plus cost plus profit, which in that case would include the prolongation cost over the duration of that compensable EOT. If it says in that column, contractor's entitlement, that the entitlement is EOT only, this means EOT without cost entitlement, and of course it follows that without even prolongation cost. I think I might stop there and hand it over to Robert. Robert, please, over to you. If you want to add something on the risks table, and then you can lead it from here, starting with the prolongation cost.
Thank you, Mohammed. I think for us to proceed, it's best way that you will share the slides, and I will give you a sum up when you switch the next slide. I think that will be the most efficient way. Otherwise, we have to stop sharing and kick in again.
Sure. Would you like me to go back to the table? If you would like to say something about the table,
maybe 1 second.
Okay.
Yes.
Okay. All right. Here we go. Which one? Doesn't
Just the
go.
last slide will be sufficient.
All right. Okay.
Easy to use. That was one of the main doctrines which guided us when we prepared the new Green Book. And here I think we have done a very significant step. This is a tabular form which collects all the employer's risk and says what is the contractor's remedy in case this risk eventuates. And if you look at that table, you will find yourself very familiar with all the wording, all the text, because that's just a collection of typical FIDIC risk allocation. So basically the text is what you have in other FIDIC contracts as well. It's just that we have collected it in one subclause where everything is collected, all the employer's risk and all the contractor's remedies. And the same principle applies as to any other FIDIC contract you know. It's just that you don't have to search in all the subclauses for the risk and the remedies in a separate way. Now it's condensed and complete and one simple to read and understand tabular form. I think that improves that we have, at least to a large extent, succeeded in making it much more user-friendly, simple to use, and straight away. Let's go to the next one and just explain that we had a term in our reference, and that said, be innovative. And so we thought, what is for us to put in as an innovative element in a standard form of construction contract? And we found quite easy that there are some things which do frequently give rise to construction disputes. And we found that it is not the subject matter of the dispute who has to pay what. That is quite simple in some situations, but the entire dispute is about how much that party has to pay. And if the risk, the entire dispute is allocated to how much, that might be a good reason to simplify the how much. Under the conditions, it is clear that one party has to pay for the other. And if the extension for the time of completion is allocated to the employer, then it's clear the employer has to compensate something, and what we have put in as prolongation cost, which applies, of course, only if the first threshold, it is clear the employer has given rise to the extension, is already clarified. And just move on, there's the slide. That's what it says. We have a formula. This formula is based on the assumption that the overhead costs are roughly 20%, which applies to a typical standard construction contract. And then we have allocated the payment depending on the period where the delay kicks in, following the assumption that there is a prime time in the middle where the contractor has all the resources on time. There should be the compensation higher than in other times. You may look at the details of the clause, but it's just a simplification. The fact is clear. There is a delay. That delay is caused by the employer, so we have to compensate. And how much, we just follow this formula, and we don't have to have a construction dispute on this question. That was the idea. This is the idea of liquidated damages. We have got used to liquidated damages as such for delays by the contractor, and we are aware that these delay damages are far away from being precise. Describing the actual damages. It's just a simplification, and we have used the same principle for prolongation cost. I think we're going to have discussion on that later, so we jump further and go to the next slide, as our intention is to give a brief overview of the Green Book. And here we have a slide which shows one feature that is part there. The table on the left part is an element of the contract data. The contract data are designed as a roadmap to prepare the tender document. So many decisions can be taken by preparing the contract data. And here we have tick boxes. And there are many tick boxes, and by this, the drafting party is deciding, for this example, how to value the work, so how to measure, or it's a lump sum, by just taking several options. The options I explained what the meaning is. So by establishing the contract data, a lot of risk elements are decided, and many decisions are to be taken. And in the way we have done it, it is clear for the drafting party that they are quite likely will not forget any decision to be taken, which could happen in other kind of contracts. Move on, please. The next slide already, okay. I think show the full slide move on the animation. And this slide is chosen by us to present here a variation procedure. And under clause 7 under the Green Book, there are two possibilities to initiate a variation. We know a variation is to be initiated by the engineers and engineers baby. And there are two ways to do it. And in our Green Book, we call it the A variation and the B variation. So we have two pathways. And if you look a little bit closer, you will identify these are exactly the same pathways as we have it in the standard form. So we could ask for a request for proposal, that would be the B on the bottom shown, or we directly can instruct a variation, which is then requires a retrospective valuations. We value the effect later on compared to the request for proposal, where that has been done before the decision is taken to execute it. And there's a line missing. That was the line I was just referring to. And in case we couldn't decide after a proposal and the engineer has the ability to direct instruct us or move it forward. And if you look at the text in more detail, you look at the Green Book text, you will identify that's the same principle as we will find in other contracts, just to use with smaller words, with less words, and directly, and they are next to each other, not hidden in 3.7 and 13.3. They are next to each other. And I've experienced that people in other contracts already start to call it a variation or B variation, where the term is directly stemming from the Green Book, where we have done subclause 7.1 in this respect. Next slide, please. Which we have chosen here to again provide evidence. Just go through the animation and we will go with a full set of the slide. There are claim procedures for the parties because we have adapted the 2017 concept to the utmost possible. So we have a claiming party and we have event-driven people that is unique for the FIDIC world. And then following the event, we have different steps. And these steps are the same as you are quite familiar with. More precisely in the 99, 2007, we have more intermediate steps. What we have more or less applied the 99 concept in respect to claims. You'll see in the middle, there's the engineer's duty to consult with the parties and endeavor to reach an agreement. What you do not find here is the 28-day time bar provision for the notice of claim. So we have all the concepts, we have all the period, but not the time bar provision, because one of the condition precedents to decide the use of the Green Book is the parties wish to have lesser contract administration resources on site. Lesser contract administration resources means the parties have not that resources, that knowledge on site to cater for a time bar provision. That's why the Green Book doesn't have this time bar provision, though it has the time periods in which the action need to be taken. The final step is then dispute adjudication. We have included that, but in a very simple way, I think very attributable to the straightforward concept of the Green Book as such. Then we go to the next slide before we hand over to other colleagues. So I think here we have also implemented something which was on a long discussion, how to deal with insurances. And in a FIDIC contract, it is for the contractor to provide the insurance and submit the full policy to the employer for the employer's approval, which requires a certain knowledge from the employer's side, but also the disclosure of sometimes business secrets. In order to handle it very easily, we have opted for an insurance certificate. So if the contractor has a proper insurance in place, he could just provide the insurance certificate. The table for the insurance, and they look a little bit annoying if you look at that. Oh my God, so many possibilities, but that is exactly what the other conditions anyways describe. So there's nothing really new. It's just a different format. You can see they are next to each other. You can look at the required insurances, and it's maybe even more likely in the Green Book scenario that the employer will provide some insurance. So not everything has to be provided for the contractor. This is an example. We just have cut it in half to put it on one single slide for the presentation purposes of an insurance certificate. So it's a rather simple way of providing some evidence that the insurance cover is sufficiently made by the contractor, leaving the option that the employer may ask for the full policy as a fallback provision or on particular request. We have said easy to use, and in order to support that, we have provided several charts to help flow charts, pictures, timelines, etc., to illustrate how these conditions work. You don't have to go to all the text in order to have this support. And this is a typical sequence of payment events, principles you make yourself familiar with in other FIDIC books. In more detail, we have provided that. Plus, we have guidance notes, so there's no FIDIC guide available for the Green Book. It's not necessary because the guidance notes are already in the books. That's the reason why the book is significantly bigger in size than the previous Green Book. That's all because we have given more user-friendly support for the users. And I think we move to the next slide, which is something which is very much appreciated by the industry, that as the communication forms. They follow the concept. We communicate in a FIDIC world by giving or receiving notices. So we don't write letters, we give and receive notices wherever the contract says so. And the idea is that the contract specifies who has to give notice about what. It's a transfer of a message. And whenever the conditions require the party or the engineer to give a notice, we have drafted a form. We have identified 40 forms here, and once we were done, we had a big smile in our face because we went through these forms again and found out that they would apply to any other FIDIC contract as well, because they are just referred to a well-known FIDIC concept. The only reservation is you may have to change the subclause under which the notice is issued. That listing is a little bit different in the Green Book compared to 99 or 2017, but many of these forms would be absolutely suitable to be submitted under other FIDIC contracts. As we haven't identified new issues, we just have applied the FIDIC typical principles and FIDIC typical concepts for contracts. I think that should serve it for now. And I'm hand over to my colleagues who will give their view on the Green Book with their practical experience, and then we move on to the discussion, and I'm happy to answer any question you may have later on. Thanks for now.
Thank you, Robert, and thank you, Mahmoud, for the very detailed presentations. We already have some questions for you in the chat that we will take right after the two other presentations. So for now, Richard Touroud will present the general feedback of the contractors on the Green Book and highlight a few items that may be improved. But first, before you start, Richard, let me introduce you to the audience. Richard Touroud is the Director of International Affairs of the French Federation of Public Works and CEO of the Syndicat des Entrepreneurs Français Internationaux. He is also a member of the Commission Europe Internationale of MEDEF, the main French employers' union, member of the board of directors of MEDEF International, and vice chair of the BIAC, Business at the OECD's Development Committee. In 2023, he is a co-founder of the Society of Construction Law in France, in which he represents the Commission Public and Private Contracts. Previously, Richard has been, among other prestigious positions, head of the legal department at Renault Group. He also worked for what's now called Artelia as head of the legal and export finance department, for the French consortium Interinfra, in charge of metro projects worldwide, for the project management for Euro Disney, and also as legal director and then general counsel of now called Vinci Construction Grand Projet. So thank you, Richard, for your presentation.
Thank you, Fanny.
You will share your slides. Yeah.
Thank you, Fanny, for your kind introduction, and thank you, Daduna, for inviting me to speak to this webinar. I now have to share my screen for you, and hopefully you will see this. I hope you do.
Yes, we do.
Okay, let me put it in diaporama form. Okay. Okay. Now, we had been very glad in 2021 to be invited as friendly reviewers of the new edition of the Green Book. And we were extremely happy that a number of our proposals had been accepted by the Contracts Committee. Still, we understand that some of our proposals could not be accepted because nobody's perfect. And this is the reason why we listed a number of issues in the current Green Book drafting, which may deserve, if possible, a negotiation between the contractor and the employer. And if no negotiation is possible, which happens in public contracts, then the contractors have to pay attention to those particular provisions, which, in our opinion, may cause some additional risk for them. So let me start with 1.1.27, the definition of laws, where regulations appear, but technical standards do not appear. So since we are not certain that technical standards fall within the definition of regulations, and knowing that technical standards have a tendency to evolve with time, this may have an impact in the interpretation of the change in law provisions. And this is the reason why we should, in my opinion, again, add the words technical standards in the definition of laws or in the sub-definition of regulations. But you'll tell me it's a technicality, but technicalities are important. In the following provisions, 3.2.3 and 3.4, I would like to draw your attention on some ambiguity, because in the clause 3.4 below, you'll see that there is no exception in the authority of the engineer, which will be unable and entitled to relieve the contractor from any duty, obligation, or responsibility. But in 3.2.3, which says basically the same thing, there is an exception, because it says, except as otherwise stated in these conditions. So in our view, this is kind of ambiguous. The following provisions which I'd like to comment is 4.1, where plant and materials on site, this is highlighted here, shall be deemed to be the property of the employer. Well, it's standard practice for contractors to bring on site more plant and materials than theoretically needed. And this is to face possible breakage, theft, or other deteriorations. But how will the contractor be entitled to take away its surplus plant and materials after taking over of the works, if such surplus are deemed to be the property of the employer? So this is something that should be specifically dealt with as an exception. It is not the case for the moment. The following provisions, 4.4.1 and 4.4.2, deal with subcontracting. And this is really important. There is no exception here to the rule imposing the engineer's consent to the choice of subcontractors by the contractor. There is a contradiction remaining between this rule and the following clause 4.4.2, whereby the contractor is fully responsible for the subcontractor's works, acts, and defaults. If the contractor is fully responsible, he should be at the liberty to choose its subcontractors, at least for non-essential parts of the works. If you impose the engineer's consent, it implies that the engineer has a better knowledge of the subcontractor's skills and capacity than the contractor itself, which is generally not true. And not only does this clause enable the engineer to put illegitimate pressure on the contractor, it could also be an incentive on dishonest engineers to seek undue advantages from the subcontractors that they impose against the contractor's wishes. In the following provisions, I refer to the problem of commencement of the works. And here it's a little bit tricky. We believe the issue is not fully addressed. In those provisions, the effective date of the contract is the date of signature of the contract agreement by the employer, okay. But then the commencement date, which is to occur no later than 28 days thereafter, then the commencement date is determined by the engineer. But here the usual conditions precedent to either of those two dates, such as the issuance of bank guarantees, access right, site position, advance payment, they do not qualify as conditions precedent, and we see this as a problem. Let me give you two examples. 451, which you can see here, stipulates that the performance security must be given to the employer no later than 28 days after the contract's effective date. The time limit is the same for the commencement date. What happens if the performance security is not given before the commencement date? I don't know. Second example, according to 823, which you see here, advance payment, the advance payment must be paid within 28 days after the date where the employer has received the advance payment guarantee and the performance security. Unless both guarantees are issued on the date of signature of the contract agreement, it's very unlikely that the advance payment may be paid before the commencement date. And this will be a problem for the contractor, who will be legitimately reluctant to start work before such payment. Eventually, in the contract data, close to 1.1 here below, access right and site possession are granted X days after the commencement date. Normally, access right and site possession are conditions precedent to the commencement date. They should not happen before. They should not happen after, they should happen before. Unless the contractor is in charge of the design, start installation starts on day 1. Now, the last one, advance payment 823. In order to solve the problem that I raised above under 611, the one on top of the page, the time limit for submittal of the bank guarantees and for the payment of the advance should be reduced so that they become a condition precedent to the commencement date. And to sum it up, instead of being arbitrarily determined by the engineer at its discretion, the commencement date should be the date when all conditions precedent are met, including access right, site possession, and last but not least, advance payment. Let's move on to the following clause, 651, also a very important one. Here it says that, that's the final sentence highlighted in yellow, the total amount that is due under this subclause shall not exceed the maximum amount, if any, stated in the contract data. I have a problem with if any, because if any means that there is a possibility for liquidated damages not to be capped, and this would be a big problem. So we would like this if any to disappear. As it is present in the drafting, it could encourage some employers to take advantage of that possibility. And this would have adverse results. Bad contractors would accept unlimited LDs, uncapped LDs, and provide poor quality work or go bankrupt if late. And good contractors, on the opposite, will either refuse, depriving employers from their cooperation, or negotiate, if possible, to change the clause before signing the contract. In all cases, employers and contractors have a joint interest in a fair clause where LDs must be capped. In 652, there is a technicality here. It says that if any part of the works are taken over, then before the global taking over certificate is delivered, the amount stated in the contract data for each day of delay should be reduced in proportion that the value of the taken over parts bear to the total value of the works or section, as the case may be. This is fine, but what about the total amount? Because if the daily amount is reduced, it does not reduce the overall risk unless the maximum amount is also reduced in the same proportion. And this is something which I believe has been missed in the drafting. In the next page, which I cannot have access to. I'm sorry, but I have a problem with the following page. Maybe, Andine, you could step up. I cannot move on.
Did you try it with the pad, Richard?
Yeah, it doesn't work. It doesn't work anymore. So we'll stop sharing, and if you can just take over.
Okay.
The buttons do not work.
Daduna, would you like us to take a question in the meantime, or?
We can do that. We can do that, or maybe even if Robert or Mahmoud would like to share anything regarding any points raised by Richard in the meantime.
I would like to, Daduna, if I may, and if I may, Robert, I think Richard has raised several points, and I think we, although of course the intention is not to have like a debate or a response to each and every point. Obviously, this is not the intention at all. But I think maybe Richard, you can choose one or two, and I can easily explain at least why the provisions are drafted in the way they are now, and what is the intention behind that drafting. There is a logic and I would say view behind drafting that. For example, if you take the one about 4.1.1 about plant and material, obviously this is for the protection of the employer, especially in cases of termination for default. Obviously, we understand. Contractors' equipment, plant and material, you raised the issue about the surplus, and it's quite clear, you are right. There is also equipment that may have been hired, not owned by the contractor. So that's why if you read the phrase that precedes the part about all plant and material on site shall be deemed to be the property of the employer, the beginning of that sentence says, to the extent consistent with the laws of the country. So that provision about the plant and material on site will be deemed to be the property of the employer, although for a good reason, which is in case of termination for default and the employer would like to hire another contractor to complete the unfinished work. So he needs the plant and material until the uncompleted work is completed. That is only governed or allowed subject to the governing law or the laws of the country. And by the way, this is not only in the Green Book. I think it's also in the red, yellow, and silver.
Yes.
I mean, the point about subcontracting, there's definitely no intention behind providing the engineer another vehicle to malpractice or to, I would say, pressurize unjustly the contractor. What is intended here is to same validation and vetting that the engineer would help the employer with during tendering for the main works to appoint the contractor or to select the contractor as part of the bidders. So capability, equipment, resources, past experience, financial standing, all the bits and pieces of the qualification and vetting will apply to any new. I think the part that is really important not to miss, we are talking about subcontractors that are not named in the contract data. If you read 4.4.1, it says except for subcontractors named in the contract data or for suppliers of material. So if it's a supplier of material or a subcontractor that was listed by the bidder before being selected and awarded the contract, and those ones made their way to the contract data, then there is no more approval or consent, let's say, let me be very accurate. there's no consent required in that case. So I think the other point is probably with any FIDIC contract, not only the second edition of the Green Book, the guidance notes are a must read. You know, when I started using the 99 Green Book, I don't know, 12, 13 years ago, I was really, really relieved when I read the guidance notes. The guidance notes will explain to the reader or to the user what was what the drafter or the drafters had in mind when they drafted the contract, and what do they mean and what is the intention. And as such, and I would like Robert also to chip in, I don't want to take much more time. So the other point that is equally important about reading the guidance notes is also reading the whole contract, not only the general conditions, but they have to be read in conjunction with the contract data and the particular conditions. So, for example, your good point about the delay damages cap, I can assure you on behalf of FIDIC, there is zero, there's probably a minus percentage that the intention about, if any, in parentheses, this is meant to give rise to cases whereby it will be uncapped or it will be unlimited. Because in the contract data, there is a field for that cap to be stated. If any is somehow mentioned, because sometimes you express that in a monetary value, in a dollar value, and sometimes you express it as a percentage of the contract price. So, and this, by the way, is the case since the 99 suite. So we inherited that, but the intention is never to have an uncapped delay damages. The other proof I can give you, if you look at the 2017 suite under 15.2.1, grounds for termination, a new ground has been added when the cap of delay damages is exceeded. And I was one of the people, if I'm not the one who suggested it as a friendly reviewer. So the younger sibling, the Green Book, or the big siblings, the red, yellow, there's no way it is in our mind or in our intention to have an uncapped delay damages. So again, it has to be read in the general conditions with the particular conditions, and in particular, the contract data. Over to you, Robert, if you would like to say something.
Just one sentence. One of the doctrines in contract drafting in the FIDIC world is don't change what ain't get broke. So when we had provisions which were existing 99, which survived in 2017, so obviously there was no reason to change it. We felt ourselves not obliged to interpret or change that in the Green Book. We just applied the Green Book conditions. So you have raised, I think, all the points of the Pink Book 8.1. Where obviously from the contractor's point of view, that is a preferred situation. But as that has not found its way into 2017 as such, we don't have implied that in the Green Book in order to have the Green Book consistent in the FIDIC environment, which was one of the doctrines we had. I think more points we will discuss later after Peter's presentation. We don't cut them short here.
Thank you, Robert and Mahmoud. In the meantime, Richard, your presentation is back on the screen, so you can maybe terminate your few points.
A couple of issues. First, bank guarantees. If you take a look at 853 and 454, you'll see that the alternative to the provision of a retention money in cash may be a retention money guarantee, and the form of which is attached in the document. But it's a pity that it's only a fallback position. The principle should be that the retention money guarantee is provided, and the exception should be that a retention money in cash is provided instead. Here, it's the opposite. The retention money appears as the exception to the principle, the principle being the cash. And in our opinion, it's too bad because it's a missed opportunity. The time period of 21 days for the return of the performance certificate, for the return of the retention money guarantee is way too long. and same in 454, the time period of 21 days for the return of the performance security. We believe that there is no need of 3 weeks to return an original document. Following slide, please. Final payment and delayed payment. Final payment, well, the engineer has 28 days to issue the final payment certificate, and then the employer has 56 days to pay the amount certified by the engineer. Really, 56 days, I think it's twice more as in the 2017 suite. Not sure, but really it is too long. And 872 deals with delayed payment, and it provides a 3% rate above the annual rate of the central bank in the country of the currency of payment. 3% seems very low, especially because here we are talking equity or quasi-equity money. So 3% is really very modest. Last slide, taking over certificate, 28 days after receiving the contractor's notice, then the engineer has 28 days to issue the taking over certificate. If you compare to the 99 edition, there was no time period. It was immediate. I think this is a deterioration. And from the contractor's perspective, there is also a question: what happens if the engineer remains silent after the expiry of the time period? The clause doesn't say anything about that. If the engineer does not provide the certificate, what happens? I don't know. You referred, Robert, I think you referred to the insurance certificate, which is, I believe, a progress, but still in 12.1.2, there is a final provision that says that whenever required by the employer, the contractor shall produce the policies of the insurances, which the contractor is required to effect under the contract. So we have the problem of returning to the problem that the insurance certificate was supposed to solve. Like you rightly said, the contractor is really always reluctant to provide the contents of its insurance policies because it's sometimes business secrets. In every instance, it's confidential at least. So why do we keep this obligation for the contractor to provide the actual policies when we have a nice insurance certificate which should be satisfactory for every party? It's a question. And that is all. I could continue with other provisions, but I don't want to be too long, of course. Thank you.
Thank you, Richard, for these thought-provoking comments, as always, and constant wish for improvements. So I'm sure we can continue the discussion later on. So now I will turn to Peter, who will present the employer's view on the Green Book and some use cases. I will first introduce Peter. So Peter Mettler is the group leader of the Project Portfolio Management Group at CERN, the European Organization for Nuclear Research, based in Geneva, Switzerland. The PPM group develops all large construction projects, new build and renovations on the CERN sites in Switzerland and France. CERN's current project portfolio consists of approximately 20 projects in various phases of development, which are delivered using various FIDIC contract forms. Ongoing projects include 2 new large and sustainable mixed-use tertiary buildings, one of which with a mass timber structure. Peter obtained master's degrees in civil engineering from UC Berkeley and architectural engineering from KU Leuven in Belgium. He started his professional career at Arup in London, and after 10 years spent in consulting engineering in the UK and in California, he joined DEME Offshore, an international EPCI contractor based in Belgium. In 2015, he moved to Switzerland to lead the civil works for CERN's high luminosity LHC project, from concept design until completion in 2022. Peter's professional experience spans across different parts of the construction sector, and he worked on both above ground and underground projects, onshore as well as offshore. So thank you, Peter, for your participation today. And I leave you the mic. And we can see perfectly your slide.
Okay, thank you. Thank you for the invitation. I'll just start by giving a quick introduction to CERN and then describe how we're using FIDIC contracts, and then more specifically the 21 Green Book, and some feedback on our experiences to date. So CERN, for those who don't know, is an international organization based in Geneva, but we have sites both in Switzerland and France. And it's basically the world's largest research center for particle physics research. So we have a whole accelerator complex with lots of physicists from around the world that use our accelerators to do particle physics research. As an international organization, we're funded by 24 member states, and we have 10 associate member states that are about to join as a full member. We've got about 2,500 staff, but there are every day around 7,000 people on site. So we're actually a little village just outside of Geneva. That's kind of an aerial photograph. We've got two main sites, Meyrin in Switzerland and Prifsa in France, with in orange the accelerator ring of a circumference of 27 kilometers. You see the Mont Blanc in the background, you see Lake Geneva, and up in the center is the city of Geneva. CERN is mostly also underground. These are kind of the detectors that are used for particle physics research. We also have quite some buildings above ground, but the beauty of CERN is underground. CERN has been using FIDIC contracts since I think the early 90s, when the LHC project has been built with 87 red books. There were 4 big contracts. Those works were completed in 2005. Then the upgrade of that LHC, our biggest accelerator, occurred pretty recently, but using the 99 red book, completed in 22. The 2017 edition was just came out when we were tendering the works, or when we had just signed the contract. And we've built a new visitor center called Science Gateway with the 2017 red book. We've also used the gold book for a design, build, operate contract of a data center. And at the moment, we're working on these 2 new buildings, tertiary buildings, office buildings, 777 and 140, where we will use the 2017 yellow book, in addition to various small and medium-sized projects where we're using the green book. So here's just a little impression. Next time you visit Geneva, just take the tram to visit CERN's visitor center. It's a building by Renzo Piano. It's a pretty neat place to visit. These are kind of the tertiary buildings that we're currently developing on the site, but this is with yellow books. So on small and medium projects, our objective was basically to harmonize all construction contracts for projects in the range of 2 to 15 million. As many international organizations and clients, we used to have general conditions for all contracts at CERN, but we saw the shortcomings and limitations when those general conditions were used for construction projects. So we have made a first attempt to use the first edition of the Green Book contract in the past, but now recently, since the 2021 edition came out, we have managed to kind of transition our entire portfolio of the smaller to medium projects onto the new Green Book. And we would then always use it in combination with 2017 White Book for the consultant, and then the contractor follows with the Green Book. Our objective was to just have a very clear and consistent approach that whenever a contractor or a consultant would interface with CERN, they would always kind of see the same kind of contracts After doing one, they would kind of get accustomed to it, and the collaboration would kind of go smooth. The issue that we're obviously having is that we're in Switzerland and across the border in France, and in this part of Europe, even though FIDIC is based in Geneva, very close to us near the airport of Geneva, FIDIC contracts aren't very often used in our context. So we are working with obviously developed world engineers and contractors that are working in quite sophisticated markets such as Switzerland and France, but they are not accustomed to working with FIDIC contracts. And there's always a bit of a learning exercise that needs to be kind of taken. And if we start then with a consultant that is providing design services and that then goes into construction administration services, they get a first flavor with their own white book, and then it helps that there's this consistent terminology and contractual concepts to then move in construction management as the engineer under a green book. We have adapted both white books and green books a bit to our taste to create kind of CERN-specific templates, both for the tender and then for the contract phases. And because we're an international organization with many member states that do not have French as a national language, but we are essentially based in a French area, we tend to tender with bilingual documents, basically in French for the local market. And if there are companies that are coming from other member states, but that find the project attractive, they can easily kind of get to work with CERN through English version contracts. And as such, CERN provides an industrial return to their member states. The French translations were mentioned, so we took the white and the green, got translated into French by the same team that translated the 2017 Rainbow Suite. And yes, you can get them just from the bookshop. We made a couple of modifications. So similarly to the contractor's presentation, where they would like to see some modifications in a way to balance it more, a bit in the contractor's sensitivity or in the contractor's favor. We have made little touch-ups that we find are important as the employer, but overall we think that the general conditions are pretty much balanced. I think that the contractor's presentation also showed that you need to go into the detail to find things to discuss. We kind of changed a bit the 1.4, which is the laws clause, because we are an international organization and we normally stay outside of national jurisdictions like Switzerland and France. We made the limit of liability reciprocal in subclause 1.1. We added a bit of a time bar in subclause 3.5, which is a determination clause for the contractor to dispute an engineer's determination. We strongly believe in kind of addressing issues when they occur on site. And so if there has been an event and a claim or an issue or a discussion that led to a determination by the engineer, we want the contractor to then immediately make their intention clear, whether they will kind of accept this determination or whether they would like to dispute it and basically pass it to adjudication. 4.4, we've discussed the approval of subcontractors, and I would even add that from our perspective as an employer, in addition to the approval of any subcontractors by the engineer, we as a client put our approval on top of it. Our subcontractors, they must be informed of CERN's special status and the implications that has on them contractually. And we work with a lot of subcontractors, and sometimes there are issues that occur on the CERN site. As such, as an employer, we also wish to have a right to say, yeah, that subcontractor, thanks, but no thanks. Subclause 4.5, yeah, we made some specific language on performance security. And because we are also borrowing from French practice, we introduced a new clause 5.7 to insert a mechanism to apply penalties to contractors for non-compliances related to specific contractual obligations. That may help in kind of enforce the adherence to safety rules or adherence to certain environmental practices, or more basic requirements that are stipulated in a contract related to the timely submission of contractors' documents. 8.5, we simplified the release of retention money a bit. 8.7, yeah, as an international organization, we have the tendency to pay well and on time, so financing charges were not considered relevant to us. And then we simplified the termination process a bit with 2 notices instead of 3. And then, okay, 11.1, this is a remnant of whatever happened in 2020, 21, 22. And we may need to add the effects of Trump policies probably to that list. 13.1, we added also a 20-day time bar language for the right to claim, which we borrowed basically from the Rainbow Suite. We think, as I just mentioned, that if there is an event, parties need to immediately address the issue rather than come back to things at the end of a contract. Last slide on small CERN modifications, adjudication and arbitration. We've chosen to use the process of a single ad hoc adjudicator, chosen from a pre-selected list of adjudicators, mainly people that come from the president's list of adjudicators that are then named in the contract data. Our adjudication can be called upon until the issuance of the performance certificate. And arbitration, which is for these type of contracts really a theoretical case, would only be possible after the issuance of the taking over certificate. We do not want to go into any arbitration proceedings after the project is really completed and finished. We also included a time bar for commencing arbitration. Basically, project is done and we immediately need to decide what are any further steps, if any. Rules of adjudication, we harmonized them a bit to have the same set of rules between the consultant's contract, the white book, and the contractor's green book. That's kind of a general suggestion to FIDIC, and I know that there are all kinds of reasons why that may not work in all situations. But if we work then in a white book and then a construction FIDIC contract, we typically then use the same adjudicator or DAB across both contracts instead of having a separate set and process and even procedure for adjudication under both contracts. On particular conditions, so we created a pre-filled template of the particular conditions, basically the contract data. We adopted the concept of prolongation cost. We have already used it maybe once or twice on a couple of projects with okay success. Everybody kind of went away reasonably happy with the process. Yeah, as I mentioned, we introduced penalties. The penalties are then detailed and described a bit more in these particular conditions. And on option D, the payment option D, something that we had some problems with in the past, especially in Switzerland. We added additional wording to limit unjust claims for missing bill of quantity items, which is kind of a big thing in Switzerland with very detailed and very precise measurement rules and processes. And then on the insurance table, yeah, we sought input from specialist insurers or insurance specialists from Switzerland and French to make sure that we took the standard FIDIC table and we customized them to the Swiss and the French market for reuse on multiple projects. Then on the projects that we're actually using the Green Book, we have tertiary projects, basically office buildings, smaller labs or workshops, all above ground. And we have a few lower than 5 million, a few kind of up to 15 million. If the bigger ones are then often normally used in combination with the 17 White Book. And you see the status on the right. We've already concluded 2. We've got 3 in construction, and 1 is on the construction tender is ongoing. And then we have an additional kind of pipeline of a few more projects in the coming years. And then we also have, because we're in essence a big laboratory and industrial site, we call them also machine projects because they're related to the accelerators. We've got typically more of those. Many of our buildings are quite industrial and technical, also of various sizes. Some are also underground, small tunneling, specialist underground work. Here you see also the French-English combination. Often we then tender in both languages, and then based on which contractor gets selected, we can adopt a French or an English contract. We again have a pipeline that includes a bit more projects, and also some projects that were completed in construction during the tender. Some are in design, etc. So I'll conclude with a preliminary feedback to date based on the Green Books that we have been running at CERN. We must say that during the procurement, the tendering processes and for projects in both Switzerland and France, we haven't encountered any particular issues. Even though in our local market, Geneva, Switzerland and France that surrounds Geneva, FIDIC is typically not used. We have managed to bring both consultants, engineers and contractors on board with using it. And we have also not really encountered any particular issues during construction of these smaller and medium projects in our local area. Obviously, using that contract doesn't mean you don't get your typical technical contractual discussions that most construction sites have. But from what we see, the discussions are mainly related to technical documents often written by the consultant, the engineer, or the interface between these technical documents and obviously the FIDIC contract, which is always a point of attention. From our perspective, yeah, it's quite a balanced approach. We have not seen major resistance or significant negotiation being necessary to be able to sign a contract. So I would say that it's kind of being perceived as fair for both parties. Our main risk, and I alluded to it at the start, smaller engineering and contracting firms are often quite technical, and they're not particularly focused on extensive contract management. And some may feel that even if a FIDIC Green Book provides a certain level and a minimal level of contract management for purely technical staff, it may still already be kind of a little learning curve to get their experience level to where it needs to be to properly run a FIDIC contract. So I would always kind of, if you're planning on using it, check with your typical consultants and contractors whether they're willing to take that step with you. We didn't have any disputes nor arbitration to date, but that's also kind of mostly as expected. Arbitration, we would never kind of go down that road on these type of contracts with that kind of value. So I will conclude to say that we're overall pretty happy to use and to continue to use the 21 Green Book on a variety of CERN projects. And I just want to make reference to my colleague from the CERN Legal Service, Chelsea Barrell, that is also instrumental at getting all these contracts up and running.
Thank you very much, Peter, for sharing this quite positive experience of the FIDIC Green Book, and also for the explanations on how you could customize it and fine-tune it for your purposes. So thank you very much. I think we have a few minutes left to take some questions from the audience. Maybe Daduna, if you could select some questions.
Thank you, Fanny. I'll absolutely do that. And I'd like to join you to say thank you to Richard for sharing the viewpoints and suggestions for improvement from the contractor's perspective. And Peter, thank you, and CERN for championing use of FIDIC in Switzerland and in France. I'd like to pick up a question that came first from Germany, saying that the question is that it seems that new Green Book is very similar to 99 Yellow Book. Can you briefly explain what's the difference between new Green and 99 Yellow Book? And perhaps either Robert or Mahmoud could pick up on this. We only have 5 minutes, so we'll try to be brief in our responses.
It came from Germany, so Robert is best placed to answer that, Daduna. So over to you, Robert.
I would have said the opposite, but I can easily take it over. I think the assumption that there's a comparison between 99 Yellow and the 2021 Green Book was from the presentation of the claim procedure, which is correct that the sequence is more or less compared to the 99. Otherwise, we have taken all the new principles of the 2021 conditions on board. Here and there, we have taken the opportunity to make it a little bit more straightforward, trying to comply with the principles using lesser words. So, for example, 10.3 is not mentioned in our Green Book, but if you look at 10.3, interference with test on completion, whether it's a subclause existing or not, the same principle will apply. So we think the concept is implied being the same. And I would object that there's too much alike between 99 conditions, particularly Yellow Book, and the 2021 Green Book. I would say it's worth reading it.
Thank you for your response. Should we go for the next question? Fanny, do you want to pick it up, or I can?
You can go ahead if you have one.
The next question refers to exceptional events. And in an exceptional event like war, there is a huge argument that the contractor is entitled to both cost and time in other forms of contract. Now it's boldly stated as contractor is entitled to both cost and time. So how is this handled in the Green Book? The entitlement of the contractor in terms of exceptional events like war. Robert or Mahmoud?
Well, I think in short, it's the same as in other FIDIC conditions. Here and there, the question is, why is the contractor entitled if there's force majeure? But the FIDIC concept in any contract is the contractor is there because of request from the employer who wanted to have the benefit of the project, and that needs to be taken in consideration. There is a FIDIC view in general, which might be different to others, but the Green Book exactly fits in the entire FIDIC concepts without any exemptions to the Green Book. It's just the FIDIC concept.
Yeah, and if I may add quickly, Daduna, I think the questioner mentioned other standard forms. I think if you look from the other side of the fence, people would sometimes, including me for a period of time, I was seeing FIDIC entitlement in case of war as really generous for time, EOT, and cost. Because it's EOT only because it's an exceptional event or force majeure, and we don't want to get into that debate of the definition and the legal background. But what also is worth mentioning is that war, whether declared or not, in the country or out of the country, would provide entitlement in the Rainbow Suite. And of course, as Robert mentioned, the Green Book is no exception. Thank you.
Thank you. There is another question related to the dispute resolution mechanism in the Green Book and whether that has been changed, or is it still adjudicator as provided in 15.1?
I already have answered that in the chat box.
Right.
But in short, 15.1 says adjudication in 3 lines, 99, and we have elaborated a lot more on the dispute resolution mechanism, and still, again, applying all the FIDIC contract, but in a lighter form to the Green Book.
With 3 options,
yes,
as I mentioned, with the 3 options. So it's still one adjudicator, given the anticipated capital value and volume of projects that will be using the Green Book. But there are 3 options to appoint the adjudicator.
Maybe we could take one final question, Fanny, a generic. I don't see.
Yes, maybe a question to Richard. You propose that the words technical standards should be added in the definition of laws. Risk is often best placed with the party that can handle it best. In general, contractors are more knowledgeable about technical standards than employers. Why should the employer carry the risk of a change in technical standards, as you appear to be proposing?
Well, it's an interesting question, but just before I answer this, I'd like to say, because it's important, that contractors like the Green Book. It's an excellent book. And I'm really proud that I contributed to it, even to a minor extent, because the result is really good. And I have only one complaint, that it is not more widely used, because it's really adapted to a number of projects of every kind. So it's a real improvement. Now, to answer the question, I think technical standards are evolving quickly, and the contractors are not in control of that evolution. This is why, like any other regulation or laws, it should be part of the contractor's risks. It's as simple as that. We believe that the contractor is the employer is the party that is most in position to to bear the consequences and manage the risk. Thank you.
Thank you.
Any thoughts on that, Peter, from the employers?
I can understand where he's coming from. I'm not sure whether you would need to specifically hard code the technical standards are hard coded in the contract, but as in a general sense, I agree that if we tender a project that is designed and based on a number of current standards, and during construction a law or a standard drastically changes, which has repercussions on the contractor. The contractor may feel that his bid is no longer valid. That being said, Green Book contracts are typically not very long in duration, and so it would surprise me if, in a practical sense, you would have a 1 year or whatever, 1.5 year project of such a monetary value, that all of a sudden a technical standard would change and come immediately into effect, and then immediately have an effect on the contractor. The way I know standard development, they're also not a high-speed train. They're typically kind of a the process goes a lot slower. So I think on a practical sense, such comments more belong to multi-year red or yellow books, I'd say.
Maybe a last one to all the panelists. Would you recommend proceeding with an investment of over 20 million euros with Green Book, or would you suggest switching to traditional rainbow suit contracts instead? Who would like to take it?
I can answer from my perspective. I think the money is not the magnitude in terms of money is not the only criterion to be taken into account. A big contract may be performed under the Green Book. It's not a big problem, especially if the relationship between the employer and the contractor is trustworthy. I mean, if there is a high level of trust between the contractor and the employer, the size of the contract may not be a problem. Of course, not a nuclear power plant, this is for sure. But even more than 20 million or 30 million is not a problem per se.
And I would add to that that it also depends on the experience level of the parties involved, of your engineer and of your contractor. Yeah, Green Book for projects of a lesser complexity, but if your engineer nor your contractor is very fluent in more elaborate contract management, which is definitely required under the new suite of 2017 Red Books and Yellow Books, I would be very wary to work with unexperienced partners on such complicated projects and contracts. So it depends on your market experience level. And then a Green Book could indeed be used for projects up to 20 million or more.
And I would add on the complexity of the works itself.
Definitely, Daduna. If I may, just quickly, I echo what Richard and Peter said, and what you said also. So it's not only the monetary, the price tag, or the cost, the budget alone in isolation. It's all the other, the set of criteria mentioned by Richard and Peter and yourself, also the nature of the complexity, but also if we go back to what we started as part of the objectives of drafting the second edition, is we wanted to provide the market with a tool, with a new form of contract that would serve as an alternative to the 2017 Red and Yellow Books. And this is only for particular cases, which is where the perceived level of risk is smaller compared to the ones perceived under the Red and Yellow, and or where the parties would like to use a simple form, as Peter mentioned, shorter duration, up to 2 years, 3 years max, if I would say. And also they are not equipped, they are not manned with the level of contract administration that would be mandated if they use the 2017 Red and Yellow. So there's a host of factors to be taken into account. But if you look at the 20 million alone, definitely the Green Book can go up to 30, 40, or I would say 50. There's nothing prevents that. Thank you.
Thank you very much. I think now it's time to close this webinar. We could have spoken much longer, but in any case, we will share with you the recording of the webinar. We would like to thank you, all the panelists, all the participants, and of course, Yeva and Daduna for co-organizing this webinar. I also just would like to mention that if you have any suggestions for future webinars, you can share those with us so we can improve and have some good next episodes. And Daduna, I let you conclude this webinar.
Thank you, Fanny. I would like to join you in thanking all the participants, all the speakers for excellent presentations and discussions, everyone joining us, and you and Ondine for this collaboration. And we're looking forward to continuing this collaboration and also reaching out to others to join us in those discussions in our future events. Thank you, everyone, and enjoy the rest of your day, and we'll hope to see you again soon.
Thank you very much.
Thank you.
Bye-bye.
Thank you all.
Bye-bye.
It was a pleasure. Thank you.